when it comes to the trusts and with respect to loans, you are exempt from having to pay donation tax if you don't charge interest, if the property is for your primary residence. So if I'm loaning money to this trust and the trust uses that money to buy this house that I'm going to reside in as a primary residence, then I'm exempt from what we call Section 7C of the Income Tax Act, which says that if I make an interest-free loan to a trust, and I do not charge interest, the difference between the interest I should have charged, which is the official rate of interest as stipulated by SARS, and the amount of interest that I did charge, which in this case was 0, that percentage is deemed to be a donation. So I'm taxed on that. It's a deemed donation. So now donation tax is regrettably very, very high. So you're going to be taxed on that component. That being said, it's potentially possible to try and offset it with other income and exclusions. But that being said, you definitely want to try and avoid a situation like that cropping up in the first place. Again, prevention is better than cure, especially when it comes to the receiver of revenue. You definitely want to make sure that your tax optimization strategies are in place and have been optimized and are, for lack of a better expression, bulletproof. Shitty boy, it looks like you're back.
I've been listening, so I'm not sure if you can hear me.
Yeah. Yes, we can hear you.
Okay. So no, you pretty much, I've heard everything that you covered a lot, and exactly what I was going to say. Let me maybe reemphasize that to say, transactions that you have in a trust needs to make sure that they've got resolutions. Secondly, also, any form of trusted needs to also allow you on how you're using those trust assets. If, for instance, you are using the property as a primary residence that is within the trust, the trustee needs to stipulate to agree to that, because the trustees cannot give a resolution and give effect to a usage of that while the trust is actually not empowering, the trustee is not empowering them to do that. So that's also crucial. Then number 3, also what I've seen that this guy did wrong is the loans that are going into the trust. That could potentially also have tax implications. Likely, he's not a beneficiary, but then he's a connected person. So in this case, also they can trigger Section 7 capital C. So it's a quite tricky thing that SARS might also be interested in looking at this case study, and you don't want to find yourself in that situation. So any form of loans that you have with the trust, be careful, rather reach out to people like us and be able to assist you on how to efficiently tax plan such kind of transaction. So those are some of the things that I think he did wrong. And in closing, guys, because I look at the time also went by, there are things that he did right. So of course there are things that he did right. Bruce, let me start with you. What did you see that he actually did right?
Well, in my opinion, the sequence of facts was a big win, in my opinion. Setting up the trust before he needed it was a big winner, in my opinion, right? The fact that the property was also purchased prior to the marriage was a big winner, in my opinion. But now we're speaking about facts and not law. But from a legal perspective, what I'd have to say that he did right was that, and now I'm mentioning this purely from a selfish perspective to try and get him the best outcome, and that is he did not make her a beneficiary. If he had made his wife a beneficiary, the outcome would have been a different story, right? She could have potentially relied on the likes of the Parker case, which requires a third party, an independent trustee, to ensure that the trust is separate. And then the outcome could have potentially been different. So that was a big win in my eyes. Not also, was that there were no documents in terms of which she became entitled to some sort of benefit from the trust or even in respect of her house. So now this is more a practical situation. Now, the reason why I'm mentioning it is think of the likes of a cohabitation agreement or even proof of residence for her, right? At no point was any proof provided that, listen, she owns it or she has an interest in it. And that was a big winner. And again, what I'm mentioning is, yes, factual, but it is a result of applying wealth preservation planning techniques and strategies to optimize your factual matrix.
Yes.
So that your financial predators are kept at bay.
Yes, I like that. So you basically can't sleep on the job when you want to preserve wealth. Get your facts right. You'll be able to actually protect your wealth. Lisa, what did you think in closing that he did right?
I think one of the major things he did right that played out in his favor is the fact that he never accepted any major contributions from her side into the trust that she could have argued with. She can never say like, oh, she might have bought a property or she might have bought a car, something that we then went and put in the trust, for example, because then she would have had some sort of leg to stand on. Whereas instead she was the one benefiting exclusively almost from everything and from the trust and from his contributions to her and him maintaining her. So her not having any evidence to back the fact that she so-called funded a majority portion of the finances and things that went into the trust was a big win on his side. And a side note that I would like to say is that I feel it's so important to be educated on what you're doing and the implications of such, because a lot of people do not understand that I can buy a house. If I place that house in a trust, I have to relinquish control and ownership, especially if I'm not a trustee. And a lot of people can't sort of part with that feeling of like, no, but that's my house and that's my trust. They forget that there is that separation, and that's why these lines get blurred. The same way that people forget that once you're in a union, in community of property, you sort of become half of a natural person, and you can't be acting independently without your spouse, because that can also lead to further contention. You have to remember what you're getting into, why you're getting into it, and get advice surrounding it if you don't have the knowledge, because you want to avoid issues like this and spending money and going to court and having these fallouts towards the end. So you really need to educate yourself, and if you can't get the answers, consult with those who do, consult with the lawyers, consult with tax practitioners, etc. Get that information, and rather, like you said, get your affairs in order way before you need to have them in order. Understand what you're going into. Don't be blind going into these things, because they have real life implications and expensive implications.
And I like that. I totally agree with you. And I think that's why these segments are so crucial, is about the objective of this, and the intention is to empower you to be able to ask the questions. We are not empowering you to be a lawyer. We're not empowering you to be a tax planner. Basically, we're just saying, be alert and then be able to ask questions, and be able to identify the risk and the red flags and say, listen, Shitty boy, I need help. I saw this. Can you help? You know, so for us, it's not to make you to make you the lawyers. But one of the things that I'm taking from this court that I think he did brilliantly well is the father. The father was so smart that he made himself a founder. I think that's is crucial, and it was one of the things that I'll encourage to my clients in going forward, to say, consider making someone remotely not related to benefiting in the trust, like the grandfather, but then they need to have some sort of a self-interest also into the well-being of the beneficiaries. So grandfathers are always the people that should be starting this trust. So I think that he did this, that was a master stroke. And then I think the secondly, from structuring point of view, he didn't make himself a beneficiary in whatsoever period of the trust, which was smart, because you can pretty much say he doesn't have any interest in the trust. So that's why he is smartly on top of that, and which is one of the things that from tax planning point of view, it's a sensitive area where the wealthy and the rich are living through loans. So he has been living through loans, which was smart. So I think from financing optimization, he did a smart thing, but be sensitive when you start using such kind of strategies, because SARS is not going to be happy with that kind of arrangement. But that was smart. And one of the things also what I saw that he was smart when it comes to financial literacy, because he didn't close his bond. Upon settling that bond, he did not close it, which helped him subsequently, because he went and made the trust unattractive by raising more debts within the trust. So, which was a master stroke again. The guy was a genius. I must give it to him. So those are some tactics that some of you guys can use. They're legally so, but it helps with preserving wealth. So, and one of the things also is crucial is that the trust was discretionary trust. So, which is good, which is a master stroke also. Consider having a discretionary trust. Another thing that I need to highlight is that they made his kids, the grandfather rather, made the grandchildren capital and income beneficiaries. So that also distinguished and distanced himself away from the trust. So, which was also a very smart thing. But most people might argue, say, but how am I going to benefit in this case? I think another sort of a remote that distinguishes yourself is to consider making yourself income beneficiary, but not capital beneficiary. Then in that case, you're still living off the trust. And
you're breaking up a lot. Yeah. Okay, now it's a bit better.
Okay.
Yes.
Where did I lose you?
You said if someone asks, where do I benefit if I'm just the founder and making my grandkids? Yes.
That's good. So where I was going with this is that when someone is actually can ask to say, if I made myself not a beneficiary of both income and capital, how would I even survive? I think that is a remote, because he was he was making salary, so he didn't really care himself about benefiting from the trust. Then he lived, that's why he used the strategy of the loans through the trust, and he was getting interest-free loans from the trust, and he was just living off with no terms of paying for back then, which is smart. I must give it to him. So, but be careful on using such kind of a strategy. Rather speak to the likes of us, and we'll help you with that. So then another thing that I think you need to consider, you can consider making yourself income beneficiary, not a capital beneficiary, and then make your children or the children of your children capital beneficiary, so that you distance yourself away from the trust as much as possible, because it means you can only benefit if the trust has an income. If the trust doesn't have an income, you are not actually going to be considered. So I think those are some of the things that I think were master stroke for me, in my view. So I think you'll learn something. If you feel like there's a couple of things that you want to know and you want clarity on as a client, please feel free to reach out to us. By virtue of you watching this, you're privileged because you are one of our clients, and we are highlighting these matters to say, be informed, be in the know. We mentioned the issue of what he did wrong when it comes to trust administration. And we mentioned things like where there are no resolutions, he acted absolutely as a trust. The brother was a sleeping trustee, which is not allowed at all. He didn't have a independent trustee, which is now a master directive that every family business trust needs to have an independent trustee. We could imagine, because this trust was way before actually this directive came into light. So please don't be like him. Ensure that you actually have an independent trustee. Make sure that you've got resolutions, and ensure that when you guys who are using the trust assets, you also consider that the trustee actually empowers you to use those assets. And on top of that, then it gives you the resolution. The trustees passes the resolution to use those assets. So it's actually, you can end up even having a checklist as you're building an experience and knowledge on how to do that trust administration, because the more, like Bruce said, the more you put in firewalls, the better for you to preserve wealth. You don't want to be part of the stats where we are saying 90% of the wealth doesn't reach the third generation. So can we work towards not being part of the statistics and ensuring that we reduce the percentage as lower as possible to ensure that more and more people are able to preserve wealth? Like earlier on, I mentioned about how he structured his affairs smartly. And like Bruce said earlier on, the fact that he started this trust way before he even got married, that helped him. And also the fact that he bought this wealth way before he got married, it actually helped. So which means that you as a wealth creator, get your facts right before even thinking of getting into marriage. But I think also one thing that he got it wrong is being married in community of property. Who knows, maybe it helped him in this case, because had he married out of community of property, then section 7 could have, section 7 subsection 3 of Divorce Act could have been applicable in this incident, because he was just not administrating the trust efficiently. So that's one thing that could have been debatable. I would have loved to see that fact, because he's not even a beneficiary of that trust. I don't know how the judge was going to arrive at the conclusion that the trust assets are his. But you know, it's a law. Law is open for interpretation. Bruce, in closing, short sentence in closing, take home key things that take home. Lisa, things that they should take home, and then we close it.
Thank you, Shady Boy. Firstly, I'd like to say thank you all for watching the segment. We really do appreciate your viewership, and also the fact that you come to us with these sort of questions. It really does actually make debating these sort of aspects very interesting and stimulating. That being said, in this matter, my take home from this matter is that even in difficult factual matrices, there is a way to structure things and optimize things to obtain a strategic outcome, whatever that outcome might be.
Thank you. Lisa, closing shot?
My closing shot is very simple. Knowledge is power, even if it's not your knowledge and you have to acquire it from a third party. I think that's the best way to move forward, is just educate yourself, educate yourself, educate yourself. You can never go wrong. And even if it's not applicable to you in your personal capacity or something that you need to know, you can advise a family friend, a family member, and help them avoid making these same mistakes. So you only stand to benefit when you educate yourself and when you read up on these cases, and it's very interesting. So it's never a waste of time. And I just think, yeah, education is key.
Thank you so much. Self-development, that's what Lisa is saying. Continuously invest in self-development. And Bruce, like he said, it's crucial that you find a way, creative way to structure things efficiently, so optimal, so that you preserve that wealth. From me, Shilly Boy, I thank you, and then look forward to more segments as we assist you in wealth preservation. Who knows, in the later year, we might end up having actually a physical workshop on estate planning literacy. That will be very important and very interesting to say. Let's spend the whole day actually dissecting the issue of wealth preservation. So let's look into that. Good evening, good night, good morning, good afternoon. Cheers, bye guys.
Night, everyone.
Night all, bye.